So next, this is a case out of the 11th Circuit called Houston versus Murad Supermarket. And this sort of approved, if I can use that word, the concept of tester standing. So many of these lawsuits are brought by a fairly small group of people who themselves file hundreds and hundreds of these cases. And, they file a series. I mean, sometimes it's called a serial litigant, which just means they file a series of lawsuits. Or sometimes they refer to themselves as testers or tester plaintiffs. The tester concept is really meant to ferret out unlawful discrimination under civil rights laws that might not otherwise easily be rectified. In the ADA context, a tester plaintiff goes to different locations from place to place and encounters ADA violations and sues to cure those violations. And a lot of times these lawsuits will say that the person is filing as a tester. Now, there are a lot of requirements attached to whether a tester has standing, is the right person to file the lawsuit. But in general, tester standing has met with at least some approval. And in this case, but from the 11th Circuit, the court held, and again, this is the overview of the holding, that where a disabled person alleged that architectural barriers at a grocery store violated Title III of the ADA, his status as a tester did not deprive him, a tester, did not deprive him of standing to maintain his civil action for injunctive relief under the ADA, because the statutory text provided no basis for the suggestion that his motive was relevant to his legal rights. The disabled person had standing to seek injunctive relief because he had been to the store in the past. He wanted to return. His frequent trips directly past the store rendered it likely that he would do so, were it not for the ADA violations, and his intent to return could not be characterized or specified as someday intentions that were too speculative. So there has to be some, even in the concept of the context of a tester, there still has to be some fundamental characteristics needed for standing. So that the person went there, that they intend to return in a non-speculative way in the future. And if those are true, the fact that their primary motive for going there was as a tester does not disqualify them as a plaintiff in the case. I'm getting into the weeds here. For most business owners, hopefully these are not issues that ever have to be faced because they're going to be compliant with the ADA ahead of time. Okay. Next. So here's an example where a lawsuit was dismissed, and this is from the Northern District of New York, because it was not believable that the plaintiff actually wanted to use the services of all the businesses that she had sued. So the burden faced by an ADA plaintiff, and I'm reading from right here, seeking standing to sue alleged ADA violations on a hotel's ORS, that's online reservation system. So that's what we discussed earlier about hotels' obligations to take reservations from the disabled in the same way as they do from the able-bodied, is not high. Such a plaintiff need only demonstrate that she has a purpose for using the website and that the complaint of ADA violations frustrated such that any injury is concrete and particularized to the plaintiff, and that her intent to return to the website to book a room or at least obtain information that would allow her to decide to book a room is plausible. So this is a critical difference between the last case we looked at, Houston Murad Supermarket, and this one. In the last case, the court thought that it was plausible that the tester was going to return to the place of public accommodation that he sued. And in this one, as we'll see in a moment, the court did not find it plausible. The allegations plaintiff has made in an attempt to save her complaint after unsuccessfully relying solely on her tester status as a basis for standing are not credible. So this suggests that a plaintiff who is only suing as a tester and is doing so in a way that is not credible in the sense that it's not believable to the court that she really wants to use the goods and services that she's suing to remove barriers from, may not have standing, and this case and in fact, a whole bunch of cases filed in this court by this same plaintiff were dismissed on that basis. Here we have a discussion of serial plaintiffs. So again, serial plaintiffs are plaintiffs who file a series of these lawsuits, and some have filed hundreds. Sometimes these cases are referred to as drive-by lawsuits because the suspicion, at least, is that the plaintiff has just driven by and seen violations on the exterior. Sometimes click-by lawsuits is a term that's used for website cases. But they are all terms for lawsuits filed by a serial plaintiff who files oftentimes many hundreds of these cases. And so in this case, which is from the Southern District of Texas, the court writes, "This case is one of many controversial putative class actions proliferating around the country, brought often without notice by disabled individuals, who frequently, along with an organization dedicated to the rights of the disabled, are serial plaintiffs or testers acting as private attorneys general, challenging various entities' noncompliance in their places of public accommodation with Title III of the ADA, leading to a wide and varied spectrum of judicial decisions addressing complex issues and of policies regarding standing. Because the statute does not authorize an award of damages to a prevailing plaintiff, but only equitable relief and an award of attorney's fees, concerns about abusive litigation by plaintiffs' lawyers must be balanced against widespread noncompliance with the ADA and inadequate enforcement of the civil rights of individuals with disabilities." So this case, and frankly, I don't even remember what the holding of the case was, is just really laying out the issue that we have a lot of lawsuits being filed under a statute where there's no damages available to these plaintiffs who are filing hundreds of cases. And you know, the sheer number of cases being filed really has to be weighed against the fact that there is still so much ADA noncompliance. In other words, this is a very complicated issue. On the one hand, you have plaintiffs who are filing huge numbers of lawsuits and are serial or tester plaintiffs. And on the other hand, you do have a lot of ADA noncompliance. And the way that business owners can remove them, this is not anything that a business owner who's not in the business of ADA litigation really wants to, and by that I mean lawyers, really wants to be involved in. So the way to remove oneself or one's business from ever having to worry about these issues, serial plaintiffs, testers, standing, is just to comply with the ADA. Compliance with the ADA is, as I said at the beginning, an ounce of prevention is worth a ton of cure. Hopefully now those who are taking this course are starting to get the idea of the litigation side and what businesses don't want to be involved in, and certainly risk becoming involved in if they're not aware of and attempting to comply with the ADA. Okay. A question that I often get is whether a defendant has to be served personally. Oftentimes clients will come to me and say, I was never served with the lawsuit. The answer is yes, you have to be personally served. So just mailing a federal lawsuit to someone is not good service. Whether or not they were served properly is often a function of state law and what state law says good service is. But there is also under the federal rules the possibility to waive service. So sometimes defendants, before they are served, will receive a waiver of the service of summons in the mail. It'll have the name of the case here. It'll have the case action number here. It'll have the information for the attorney that filed the lawsuit here. And if this is signed and sent back, then of course the costs of actual service of process are avoided, and there's more time. There's extra time provided. I think it's 60 days to answer the complaint as opposed to the normal amount of time, 20 days to respond. So it's a good thing to do. Service is going to be effectuated if a lawsuit has been filed, if a waiver of service is obtained in the mail. Most people will say, I'm not signing this, but in conjunction with your legal counsel, it may be a wise thing to do in that it'll buy more days to respond. And under the rule, if a defendant does not sign this and send it back, they may be responsible for the immediately for the costs of service of process that are obtained. So this is just meant to answer the question, do I have to be served personally? And the answer is yes, unless the waiver of service mechanism rule is used. Okay, can a defendant get their legal fees in an ADA case? Very, very often asked question, right? Because so typically in litigation in general, there is what's called the American rule. So the American rule basically means that each side pays for its own attorneys, its own litigation expenses, et cetera, et cetera. Now, the American rule has exceptions. For example, oftentimes a contract, I'm sure many of you have read a contract and seen where it says that the prevailing party in any litigation arising out of this contract will pay all attorney fees and costs, or the non-prevailing party will pay the prevailing party's attorney fees and costs. So if there's a lawsuit based on that contract, the winning side gets its attorney fees paid. There are also various statutes that have a prevailing party attorney fee provision in them, as well as other fee-shifting mechanisms under various state laws and under the federal rules of procedure. None of that is anything to worry about, except that the rules as they apply to the prevailing party in litigation in an ADA case and in other types of federal civil rights type cases is a little bit different. And it really stems, all of this sort of being a little bit different stems from a case called Christianberg Garment Co., which you can see right here, cited. If anyone wants to look it up, there's the legal citation, but it's a long case. And basically it stands for the proposition that in an ADA case, a prevailing defendant does not get their legal fees unless the claim was frivolous, unreasonable, or without foundation. That is a very high standard. That is not a standard for simply getting your attorney fees if you win the case. You have to prove that there was absolutely no basis to bring the case in the first place. And frankly, there are other federal rules of procedure which allow a party to get their fees in such a case anyways. But it is not automatic that the defendant, if they win, get their fees, only that the plaintiff get their fees if they win. And so, you can start to understand the position that a defendant in ADA litigation finds itself. It's sued. It has to hire its own lawyer. It's probably never going to get those legal fees back that it pays to its own lawyer. And the longer the case goes on, the more attorney fees it might be liable for on the other side. And on top of all that, generally speaking, there is usually, in my experience, this is only my anecdotal experience, but having been involved in a lot of these cases, I can't remember a case where there were no ADA violations at all. Now, there have been other reasons that the case shouldn't have been brought. Maybe the business was not a covered place of public accommodation. Maybe the person who filed it was not disabled in the sense that it's defined under the statute. Maybe the issues were all cured and the case became moot, which is a whole other topic. It is possible to fix all the issues and then claim that there is no injunction that should issue because an injunction to force the business to fix the issues has no point since the issues are already fixed. That's a very hard defense to establish, and these are getting into very complicated issues that if anyone out there is more curious about or thinks might be applicable to their situation, they should speak to their own legal counsel about. But the point being that oftentimes these cases really are bringing to light actual ADA violations because there are so many of them everywhere. And frankly, I would imagine that those of you who have watched this are now going to start paying attention and noticing there's an ADA violation, there's an ADA violation. I mean, I see them all day long when I'm walking around. They're quite prevalent. And litigants who file a lot of ADA cases don't have a lot of trouble running into, or maybe I shouldn't put it that way. Litigants who file a lot of these ADA cases and the disabled in general are running into ADA violations all the time, okay? They're everywhere. There's a lot of businesses ignoring the requirements, and as I said, like me, anyone watching this now will start noticing, oh, there's no accessible space in this parking lot. Oh, this ramp isn't correct. And you start to notice it, and you start to notice the issues that are out there in terms of accessibility for the disabled. So my only point here really is to say that oftentimes the ADA violation really is there, even if there are other issues with the case, even if the plaintiff has filed, hundreds and hundreds of lawsuits. And because the ADA violations are really there, the case probably is not frivolous, unreasonable, or without foundation. And that really puts getting attorney fees out of the spectrum of what the defendant can expect. Now, I will say this. I represented a client in an ADA case through trial and won, and I recovered part of my client's fees on the basis that the litigation was vexatious because the plaintiff had blown the expert disclosure deadline, and without an expert was not going to be able to prove any ADA violations, and yet kept on litigating the case. And so I was able to show that it was unreasonable to litigate the case after having blown the expert disclosure deadline because it would not be possible to prevail at trial, and there was no reason to continue litigating the case. Things like that are out there and they exist, but you really need to get a lawyer. If you're involved in litigation, ADA litigation, obviously, get a lawyer in your jurisdiction who's familiar with these issues, and they'll be able to walk you through this type of stuff. My only point right now, I'm going to digress. I kind of went off on a bit of a tangent there, but the point is that under the Christiansburg Garment case, very, very hard for a defendant to get their fees in ADA cases. In fact, when a defendant tries to do that, it's called a Christiansburg motion, meaning you're going to try to get your fees in the case by showing that the claim was frivolous, unreasonable, or without foundation. But generally speaking, don't count on it.